Hello, and today I want to have a look at the defence of contributory negligence that applies within the realm of tort law. This is the defence that the claimant themselves contributed to the final injury or loss that occurred. And up until 1945, this was a complete defence. However, the Law Reform Contributory Negligence Act 1945, Section 1.1, makes it clear that this is now a partial defence, which means that a claim in respect of that damage shall not be defeated by reason of the fault of the person suffering the damage, but the damages recoverable in respect of thereof shall be reduced to such an extent that courts think is just and equitable, having regard to the claimant's share in the responsibility of damage. So what it's saying is that you establish the tort and then you would say, well, this is the damages, but if there is a defence of contributory negligence, then you would say X percentage will be reduced from those damages. Why? Because the claimant themselves helped cause the loss that has occurred. And there's a two-stage test where contributory negligence. First is you have to actually prove that the claimant was actually in fact at fault, and then the second thing is you have to show that this fault was the cause of the damage and did contribute to the damage. So if we look at the first limb, that's talking about where it's the claimant's own fault. So for example, in Reeves and Metropolitan Police 2000, the intentional act of suicide, well, it was clearly the death was clearly contributed by the claimant's own actions, i.e. taking of life, and so you could claim contributory negligence. Similarly, in Owens and Brimwell 1977, the guy chose to travel with the drunken driver, therefore there was contributory negligence. And in Stapley and Gypsum Mines, 1953, contrary to instructions, the worker chose to stay in those unsafe working conditions, therefore he had to take a portion of responsibility for his own loss. And finally, in the case of Froome and Butcher, failure to wear failure to wear a seatbelt amounts to contributory negligence, because you have to take some responsibility for some of these actions that you have failed to take. So once you can show, yes, there was an element of the claimant's own fault, like not wearing a seatbelt, then you have to show that not wearing a seatbelt actually caused the harm. And the best case of this is in Jones and Livex 1952. So the guy was sitting contrary to instructions, I think on an open back truck or something like that. Anyway, he was hit from behind with the lorry, and so the defendant said, yes, there's contributory negligence, and the court said, yes, there is a bit, because of where you had chosen to sit. You knew that there was a foreseeable risk that your negligent conduct in sitting there could cause such a damage, such as a lorry from behind hitting you. However, they pointed out if you were sitting there and you got shot, well, that's not foreseeable, and you can't say that sitting at the back at all contributed to your harm, because no matter where you have been sitting, you would have been shot. So it's to do with foreseeability, this issue of causation. Again, we can look at cases like Wagon Mound, number 1, which will help with the test of remoteness in establishing this. And the final thing is contributory negligence is usually not an appropriate a defense where children are concerned. As I've discussed previously, children are a vulnerable group, and they are less careful than adults, and this can be expected. And this was made clear in the case of Yachuk and Oliver Blaze 1949. Thank you for watching. I hope this helps.